Right, good morning, everyone. I am sorry that I am running late this morning. It's one of those life gets in the way moments. Let's go ahead and get started. This is case number 2023-31828 in the matter of the Department of Revenue and Justin Serlick versus Heather Bendl. We're here today to address a couple of different motions that were filed, primarily the Ms. Bendl's motion to vacate the child support hearing officer Neil Kaufman's recommended order regarding the driver's license suspension. And then there was a motion to dismiss that motion that was filed by Mr. Holt. I'm going to deny the motion to dismiss and just go ahead and proceed with the hearing today as the motion was filed by Ms. Bendl. So Ms. Bendl, you may now proceed.
Good morning, Your Honor. My name is Heather Bendl, and I appear today pro se to respectfully request that this court vacate the hearing officer's recommendation regarding the suspension of my driver's license for alleged child support non-payment. I raise the following points in support of this motion. The Illinois court that issued the child support order in April 2022 did so without jurisdiction. By February 13th, 2022, my 3 minor children were permanently relocated to Florida, and the Illinois dependency cases had already been closed in December 2021. Under the Uniform Child Custody Jurisdiction Enforcement Act, which Florida also follows, Illinois no longer had legal authority to enter or modify child support or support orders at that time. There is no certificate of service on it, and I was not present nor had an attorney present. Therefore, the child support order being enforced here in Florida is void on its face. A Florida court cannot enforce a foreign judgment that was entered without legal jurisdiction. Enforcement mechanisms like driver's license suspension must rest on a valid, enforceable order. Here, the foundational order is legally defective, and as such, any enforcement action under it, including the suspension, is improper. The hearing officer did not allow me to challenge the validity of the underlying order, nor did they fully evaluate my financial circumstances. I was not given the opportunity to present evidence regarding jurisdiction or ability to pay. This omission violates basic due process principles and the requirement of Rule 12.490E of the Florida Family Law's Rules of Procedure. Your Honor, I am currently unemployed except for my LLC, Orbital Reach Marketing, that I just formed a few months ago. I have had no income since a car accident in April of last year. I am actively seeking clients with my marketing company, but the economy is struggling. I have no access to my children, no tax benefits, no shared custody. I am financially destitute and indigent at this time, and I have been since March of 2024. I have been denied all contact with my children since August 2021. This court is aware that I have filed repeated motions to restore visitation and enforce my rights, but those motions have been delayed or denied without a full evidentiary hearing. To suspend my driver's license under these circumstances while simultaneously blocking my access to my children is both punitive and contrary to the best interest of the children. Your Honor, I respectfully assert that this enforcement action amounts to a deprivation of my rights under color of law, especially given that I have not been afforded a fair hearing and the underlying judgment is void. My right to parent my children and to move freely in pursuit of employment and reunification is being compromised by a process that is not grounded in valid legal authority. For these reasons, I respectfully request this court vacate the hearing officer's report in its entirety, deny the recommendation to suspend my license, and consider scheduling a hearing to evaluate the validity of the underlying Illinois order and my ability to comply with any support requirements going forward. I am not here to evade my responsibilities. I am here to restore contact with my children, protect my rights, and follow the law. Thank you, Your Honor.
Thank you. And does Mr. Serlick, do you have a response to the argument that's been made by Ms. Bendl this morning?
No, I mean, I'm not sure why I'm here, honestly. I thought this was something that the state would deal with.
It is. I just wanted to give you an opportunity to go ahead and address the court if you chose to.
No, I have nothing to say. Thank you.
Okay, and it looks like we don't have, you are not Mr. Holt.
I do have a question for Mr. Serlick on the record.
Okay, this is not an evidentiary hearing, this is an argument, so there will not be an opportunity.
I want to know what I'm going to be able to see and speak to my children.
Ma'am, you can go ahead and have that communication with him off.
Yeah, see, that's the problem. He's blocked me on all forms of contact, and you are aware of that.
I'm here to address time sharing at this moment today. It's a hearing.
Yeah, because you denied that, and you're violating my rights. You're violating my constitutional rights.
I am sorry you feel that way, and I would like to hear from the Department of Revenue. Go ahead, ma'am.
Thank you. Good morning, Your Honor. Chelsea Aubin here, filling in for Paul on behalf of the state, Justin Serlick. And I would just like to answer you the motion that the transcript having to have been provided to the court and counsel within 48 hours. And I understand something was found, however, the transcript file does not conform with Rule 2.53.
Objection. I filed a certified copy on July 4th, and it was served to the department.
Ms. Bendl, Ms. Aben did not interrupt you, and you're not going to be interrupting her. You can respond.
I act as an attorney, and I'm allowed to object.
When she is concluded, you're not going to object during another lawyer's oral argument.
Well, you guys object to me constantly.
You can object when there is testimony that's being proffered. If you interrupt again, I'm going to conclude this hearing without your participation any further. Go ahead, Ms. Aben.
Thank you. I would further like to argue that Ms. Bendl did not point out any error on behalf of the hearing officer, Neil Kaufman, as the state does have the authority to suspend driver's license under 61.13016. Delinquency exists, having been 15 days delinquent, which the arrears affidavit does show. The respondent.
Where is the registered order to enforce?
Ms. Bendl, I am not going to tolerate.
I want to see the registered UIFSA. Where is it?
You are not going to interrupt her again, Ms. Bendl. That is it.
I would like to see the UIFSA registration. Where is it in my docket?
Go ahead, Ms. Aben.
Thank you. As you can see by the record, the order has the registered here appeals have been ruled upon, and the order has been found to be here properly. The support amounts, the ongoing support is $785 a month with an arrears amount of $1,000. The state did request $1,000 in order to keep the license valid. The respondent had recently paid a $1,000 purge, which the $1,000 is well within her ability to pay. While it was not a purge, it was proper for the state to require that within the rule of 61.13016, where the delinquency did exist. The state has nothing further than that.
All right, thank you. Ms. Bendl, at this time, if you'd like to respond, you may do so.
Where is the UIFSA registration of arrears in my docket, please? It doesn't exist. And that is what I was pointing out on the 17th, June 17th. Where is the arrearage registration in my docket?
Do you have an argument you would like to make, ma'am?
I'm asking a question. If you're going to enforce all of this illegal arrearage, where is the registration of it? It's not even properly registered to be enforced.
Ma'am, I don't know that Ms. Aben or I really understand what it is that you're asking.
UIFSA registration. Florida requires it. Where is it? It was never properly registered in my docket. Mr. Serlick's attorney, Serena Baldacchino, never did it. My attorney didn't do it. So where is it? It does not exist. You are enforcing a child support on a void order that doesn't even have a certificate of service on it. I was never even served with this order prior to it being signed or after it was signed. It is literally illegal. It is a 3-page void order that cannot be enforced for a multitude of reasons. It's void ab initio. It violates my constitutional rights. I was not there when it happened, nor did I have an attorney present. I was not served with that 3-page proposed order prior to the hearing happening. I was not served with the signed order afterwards. If you look at that 3-page order, there is no certificate of service on it. Nor was it ever properly registered by my former attorney, who used to be a judge here. No one has been handling this properly, and I'm the one pointing all of the issues out. And now you are violating more of my rights by trying to take away my driver's license on a void ab initio order. So I'm asking, if you guys are going to enforce this, I am requesting, as my right to request this, where is the UIFSA registration of arrearage in my docket? You can't answer that because it does not exist.
I will make a note of your objection further that you'd like to.
You can't enforce an order that was not properly registered.
So noted. Thank you, Ms. Bendl. Is there anything else you'd like to put on the record?
Your finances.
I have zero income. I've had zero income since March of 2024, over a year. Where are these numbers coming from? Where did the 1,000 come from? That Mr. Holt, he literally just plucked it out of thin air. $1,000 in 45 days, Your Honor, and she can have her driver's license. You're basically making me pay my ex-husband ransom money to now pay for my driver's license while he continues to withhold any and all contact. Your Honor, I know you have children, and I know you know what is happening is wrong. You need to do the right thing and actually protect my children. That is the oath you took when you took that bench. He is neglecting them. I have been telling you this since January 8th. Thomas attempted suicide in his care. You have hundreds of pages of evidence in my docket that I have been serving you. And it appears as if everyone is blatantly ignoring my cries for help to get my children some much needed help and get me access to them. Morgan v. Morgan, New York, 2023 states that if a parent is choosing to withhold access, child support must be suspended during that time, because that means that the party only cares about monetary and does not care about the children's best interest. So at what point are people going to actually listen to me and start following the laws? Because all of this, since this contempt order was signed, has all been illegal. It is all illegal activity. Serena had Judge Warren sign that under the table and completely bypassed my due process. I have an email from Paige Russo 2 days after Warren signed it saying, I'm sorry, we weren't able to open your financial affidavit. Can you please drop it off to the office? I did that and they refused to take it. So I'm memorialized on the record that no one ever bothered to look at my financial affidavit filed November 19th, showing that I have no ability to pay. And then they added another $1,000 on. Where did that $1,000 come from? So now you're trying to force me to pay my rapist, who is withholding any and all contact with my children, $1,785 a month with zero income. You guys have had multiple financial affidavits showing I have zero income and I'm a full-time student. You are absolutely violating my Fifth Amendment rights. You are violating a multitude of my 14th Amendment rights. Troxel v. Granville says that I have a right to my children. You are violating that right. U.S. Supreme Court has made this decision well in advance that my liberties, my constitutional liberties, are also familial contact with my children. I have no access to them at school because he's using this void order to block them at Volusia County schools when it very clearly states reserved, not terminated. What are you guys doing to my children and I? This is absolutely a 42 U.S.C. 1983, 1985, and 1986 complaint in the federal government courts. This is also a tort claim because you are walking all over my constitutional rights. And you have been since the day you took my case in December. So at this point, Judge Upchurch, I am asking you to withdraw and recuse yourself from my case on the record. I have filed 2 motions for disqualification, and you deny it. How can you deny your own disqualification? It should not even go in front of you.
I cannot entertain an Ora Tennis motion to disqualify you.
Well, I filed a writ of prohibition, an emergency writ of prohibition, because now you guys are coming after my driver's license on an order that I have been voicing over and over and over again. There are a multitude of issues with that order, and you continuously violate my due process to my 5th and 14th Amendment rights. I am a human just like you. I am a U.S. citizen just like you.
What I would like to put on the record, if I could please, is that as a courtesy to you, I accepted the transcript that you provided, but it does not comply with the rules of judicial administration, and I will not be doing that in the future. It has to be prepared by a certified
it is prepared by a certified court reporter. It has a certification.
It was.
Just because it was done by someone else other than this racketeering circle, because this is a whole racketeering circle, this is RICO.
My point.
And I am a whistleblower, and I have protections as a whistleblower.
My point was simply trying to inform you that I accepted it this time, but I will not be doing it again in the future. Do you have anything further that you want to put on the record, Ms. Bendl?
I'm going to once again reiterate that 3-page order from Illinois is void ab initio. It does not have a certificate of service on it. That renders it void right there on its surface. UCCJEA, it violated jurisdiction. Why would Illinois sign an order when I was a legal resident of Florida?
Entertain arguments that you've already made, ma'am. You've already made your arguments on the record. Is there anything new?
When am I going to be able to see and speak to my children? Because right now you are their gatekeeper and you are violating my 14th Amendment rights to liberties to parent my children right now.
This is not a hearing today about time sharing.
I'm letting you know you're violating my rights.
I understand that you feel that way.
No, it's not I feel that way. That is absolute. You are violating my rights.
Is there anything new and novel that you would like to add?
I have no income. I have never been in willful contempt. I have never been in willful contempt. I will say it a third time. I have never been in willful contempt. Judge Warren signed that without reviewing my financial affidavit. Serena Baldacchino of Rice Law Firm proposed that order without reviewing my financial affidavit.
Yourself over and over and over again, and I'm asking you if you have anything new and different to add.
I'm just making sure everyone is fully aware of what you're doing to me right now, because every single person that's aware and not stepping in, that is part of my 1986. You have the ability to stop this collusion and corruption and violating my rights, and you are not.
I understand that you feel that way.
Again, it's a constitutional fact.
Just for your that this wasn't a contempt hearing, it was a driver's license hearing, and under 61.1316, 15-day delinquency, and the amount requested was actually less than the ongoing and arrears payment.
Yeah, that's my question. Where is that dollar amount coming from? Where are you plucking that dollar amount from? I have no income. You can't just pluck a number out of thin air. You have to actually go off of a person's income. You have multiple copies of my financial affidavit. Where are you coming up with that number?
I believe I have heard all of the new argument that anyone has to offer the court, so I'm going to go ahead and conclude today's hearing unless there's anything new and different that you would like to
No, there is an emergency writ of prohibition filed with District 5 Appellant Court right now.
Okay. Well, perhaps they can clear up some of this stuff for you.
Yeah, I would appreciate that because you're enforcing a void order and what you're doing is illegal. You cannot enforce an unregistered void foreign order. You can't.
I understand that you feel that way.
It's a legal fact, ma'am. I'm following the law. You're not. Have a great day, everyone.
And I apologize for starting late today. I do apologize. Thank you.
Thank you, Your Honor. Okay.